My name is Phil Goss, and today we're going to discuss restrictive covenants and non-compete agreements. First of all, let me state that some states in the United States do not allow for restrictive covenants or non-compete agreements. They're absolutely statutorily precluded. So it's very important that before you even think of doing anything along these lines that you check with your state laws. Restrictive covenants are a very popular subject with martial arts schools. And the reason is because unlike a bakery where you have a baker baking a cake selling it to the public, a martial arts school you have employees who have developed relationships with students and with families. And when they leave, you don't want them leaving with both the knowledge that you've given them and the names, addresses, and relationships of the people that you've worked so hard to become part of your school. So it's very important that you understand whether you can or cannot expect someone to sign a non-compete agreement. First of all, you must have what's referred to as a protectable legal interest. And what that means is that if it's your receptionist or somebody that works on your website, likely you're not going to have a protectable legal interest to require them to sign a non-compete agreement. However, I would say any of your instructors and your main instructor or whomever runs a school in your absence, that would be a perfect example of a protectable legal interest. Very important that it be reasonable in scope and reasonable in duration. That's what the law looks at. It can't be for 15 years anywhere in the United States. It has to be reasonably attuned to your market. So for instance, if I'm in Knoxville, Tennessee, I think it's appropriate that it would be within Knoxville, Tennessee for a period of a couple years, maybe 2 years, or within a geographical location defined by the counties, or defined by a concentric circle of 5 miles, 10 miles, whatever the case may be. In my home state of Florida, under 6 months is presumptively proper. Over 2 years is presumptively improper. So you have to come within those parameters for the court to decide what is proper. But the court can rewrite it if the court believes that you've asked for too long, but the geographic limitations is appropriate. They can rewrite part of the agreement and leave the other part alone. Very important to understand that this must be enforced uniformly. It's going to be very difficult for you to try to enforce a non-compete agreement against one employee when you fail to do so against another employee. So if you make the commitment and the determination to have non-compete agreements, they must be enforced uniformly. Finally, they must be in writing, and the writing must be signed by the employee. This could be in relation to or in conjunction with your employee manual, or it could be a separate document. But again, if it's not in writing and it's not signed by the employee, it will not be enforced. So the bottom line, what I'd like to leave you with, a non-compete agreement is appropriate under certain circumstances for martial arts employees, but do not try to overreach by too great a scope or too great a duration, or to try to have each of your employees execute a non-compete agreement.